Well, greetings, test takers. This is Dean Tenney coming to you from my studio in fabulous Las Vegas. Shout out to the Momentrix team and Jordan over there for giving us permission to explicate Momentrix practice test content on the channel. Originally, it reached out to me for an affiliate marketing or review of their material and content. And I said, hey, what I'm more interested in is being able to give free look to your content through the YouTube channel. So anyways, this is a 63 practice test. We're working our way through. I pay for it. I just paid for this minutes ago. And then we'll do real live review and I'll comment as we explicate the exam itself. Let me know what you think about it because I'm working my way. Some of theirs, like anything, right, have been better than others. We have next up their Series 6 practice test. All right, number one. Which federal legislation do individual states use to establish uniform and understandable securities laws? I kind of like the takeaway on this. You're getting tested on what's called a template. You're not getting tested on the actual rules of your state, right? So that's called the Uniform Securities Act. I was reading Ricketts' memoir about the founding of TD Ameritrade, and he said that he had to go around and take a bunch of individual state tests. So I don't know how long ago that is. Thank God we have the Uniform Securities Act template. Otherwise, you'd have to be taking tests in all kinds of different states. So the answer is C. 2, which type of transaction is not covered are the anti-fraud provisions? Which is not covered are the anti-fraud securities. Again, as I do these, a completed sale of security, a contract agreeing to sell, a direct offer. I'm not a big fan of this question, but given this answer set, I'm going to go for D. I will put into the video description the actual answer key, and we'll see how I do on this, but I'm going to go for D on that one. Which act? I don't particularly care about the question as part of the explication, so is me commenting on whether I think the question reflects what you're going to encounter or not, and probability, high probability, low probability. Remember, you're supposed to hit pause, answer, then hit play and see how your answer compares to mine, and we'll see how we both did. Which act established the division of responsibility between state and federal regulators? I would definitely know this. This is the National Securities Market Improvement Act. And the biggest thing for you as a test taker on 63 is it created basically 2 buckets of things that are federally covered. Federally covered investment advisors who have assets under management of 100 million or more can choose over 110. You're federally covered as an investment advisor, and federally covered securities. New York, NASDAQ mutual funds, and Reg D private placements, for example. So the answer to 3 is A. 4, which of the following establishes special requirements for publicly issued debts in excess of 5 million during a 12-month period? I think this is low probability, but this is the Trust Indenture Act of 1939 that requires a contract between the issuer and the trustee for the benefit of the bondholders. I wouldn't worry at all about the 5 million, and I wouldn't worry about the 12-month period. I would just know the Trust Indenture Act of 1939 requires a contract between the issuer and the trustee for the benefit of the bondholders. In other words, if the issuer defaults, I don't contact the issuer, I contact the trustee, who is a commercial bank. 5, the Graham-Leach, the Graham-Leach-Biley Act protects investors by requiring investment advisors to, establish, provide full disclosure, be registered with the SEC, establish, protect clients' non-public information, establish standards. Well, again, I don't think you're going to see this, but the answer is C. As I said, we're kind of doing this on the fly, and I wouldn't worry at all about that. But basically, this is Regulation SP. And you'll see it, I think, as Regulation SP, not as the Graham-Leach-Biley Act. If you're a senator and you come up with the idea, we name it after you. And so, these are the Senator Graham and Senator Leach that came up with this thing. You'll see it on the test as Regulation SP. Now, remember, the time I don't have to protect your client's non-public information if it's the government that's seeking it through a subpoena, through whatever. Definition of a person. So you have 2 types of persons. I like this one. A person is somebody who can be legally held accountable. And we have 2 types of persons on the test, both of whom are legal persons. We have natural persons, living, breathing human beings, walking planet Earth. And we have unnatural persons, not living, breathing human beings walking planet Earth, corporations, for example. Those are legal persons. The point is they can be held accountable. Now, the other thing you should know is who's not a legal person. The Uniform Securities Act is actually a legal test. And in law, not only the Uniform Securities Act, minors can't be held accountable. Persons now deceased can't be held accountable for their behavior, and people declared mentally incompetent. So I would suggest as a test taker, rather than learning what is a person under the Uniform Securities Act, is make sure you know what is not a person under the Uniform Securities Act. 7, well, which type of person? Now, remember, this doesn't mean a living, breathing human being. It means, it could be either a natural or unnatural person. So what type of person must be registered under the Uniform Securities Act? A broker-dealer, a registered rep, a securities analyst, an employee of a broker-dealer. So, I think the registered reps on the test would be agents. It doesn't say agent. So you will not see the term registered rep on the test. You'll see the term agent. So that being the case, we're going to go for A. 8. Under the Uniform Securities Act, defines which of the following is an investment advisor. So you are not an investment advisor. You are an investment advisor rep, and that is a testable distinction. It's a firm. It's not you. The investment advisor is an unnatural person. A federally covered investment advisor. No, federally covered investment advisors are not covered under the Uniform Securities Act. That's the whole point of being federally covered. I have a lecture like Who's Your Daddy, right? It's either SEC or Feds. Broker-dealers, no, broker-dealers make money through transactions, not through fees. And financial planner, there we go. In fact, financial planners give investment advice. They meet the ABC test. They give investment advice. They tell people in their business of giving investment advice, and they want to be compensated for doing so. So the answer to 8 is D as in dog. On the Uniform Securities Act, a person is considered an investment advisor. I suggest you use the ABC test. Do they give investment advice? Do they tell people in their business of giving investment advice? And do they want compensation for doing so? 9, as an incidental part of the business. So that's a big pivot word on your exam, incidental. Receives compensation for advice. So we're going to use the Sesame Street trick here and look to see who is different. As a regular course of business, he provides securities advice to unrelated persons. As a regular course of business, he receives compensation for securities advice. So far, that meets the definition the most, right? A, B, C. Incidental, well, there we go. So incidental throws out A and D. That leaves us with B and C. And regular course of business provides advice. You got to be compensated. So B could be a broker, right? A broker who is giving investment advice, and the advice is free, and then you get paid through transactions. So the key word here is compensation. So the answer 9 is C. What defines a person associated with an investment advisor who manages accounts? That would be you. Well, I shouldn't say you. I forget. We're taking a 63 here. This would be somebody who's going to take a 65 after the 63 or 66. So as you were, these are called investment advisors. And with 63, you're not going to do that. With 63, all you're going to be is an agent of the broker-dealer. If you want to be an investment advisor rep for an affiliated investment advisory firm, you're going to have to take another exam. I know you're excited. 65. I would imagine some of you taking the 63 are going to be done after this. What I mean by that is, you're done. You're now going to have your SIE, your 763. But I would imagine that some of you are taking a SIE 663, 65. So you've got one more, leg of your testing journey, so to speak. Or, you might be taking you wouldn't be watching this video if you were taking the 66. All right, 11. An investment advisor would not be required to register in a state it conducts business if the investment advisor's clients are institutional investors. Yes, institutional investors are capable of protecting their own assets. And so these rules are all about protecting Joe's six-pack. So I like this one so far the best, but RTFA, read the full answer set. I just missed one the other day because I didn't read the full answer set. I said D, I thought said all of the above, and it said none of the above. That's a huge difference. The investment advisor clients travel outside the state. If I'm an investment advisor who has clients who are not residents of that other state, I don't have to register. An investment advisor's existing client relocates to another state. None of the above. Given that answer set, A is our best answer, right? So if you travel outside of the state, I may or may not have to be registered, but A is certainly the one. C, I certainly do. And then here we go, right? None of the above. Be careful of that one. The answer is A. By the way, people get hung up on this all the time. I don't want to have a debate with you. Go to the video description. You tested on having the best answer. And given that there's two answers you like, you got to pick the one that's best. And if they disagree with you, you're still going to get it wrong. I'm telling you, they can use right answers as distractors. And that's why a lot of questions say, what best describes, or what's the best answer, right? So just keep that in mind. I went round and round with somebody the other day about, they liked an answer better. I said, well, I don't know what to tell you. That's not what this particular question is about. It won't be on your exam. So if you want to be willful and, miss the question, be my guest. What is not an example of an exempt security? I kind of like this. It's kind of confusing, but exempt securities are a noun. It's a list. It's a list. And an exempt transaction is a verb, how we sell it that makes it exempt. So, it's a laundry list. You should not be struggling that municipal securities are exempt, right? Municipal issuers are exempt, and therefore the securities they give birth to are exempt. Securities for trust companies. That's true, but that's not a big deal. Investment contracts for employee stock purchases. Yep. Private placements. No, private placements aren't an exempt security. Private placements are an exempt transaction. Now, I know that's splitting hairs a little bit, but welcome to your exam. Welcome to your exam. 13, which regulatory agency determines which information is required for registration? So it's the state administrator, right? And by the way, if you're struggling between the state and the feds, I have two levels of protection. I'm coming to you from Nevada. As a retail investor, my state administrator here in Nevada, and federally the SEC. I would remind you, though, that the 63 is a state-mandated exam. Some states require it. There's a couple of states that don't even require the 63. So, my point is your default should be that, I think the SEC is got it and state administrators think they are. So the state administrator is going to be more important for us on the 63, right? The maximum amount the state administrator may require for a surety bond for an investment advisor who has discretionary authority over clients' funds. I don't really like this. It's a discretionary authority only is 10. And that's the answer to this. But remember, if they have custody, then it's 35. So again, that would be the state administrator. Then remember that the investment advisory is different than the broker-dealer. The state administrator can impose upon a broker-dealer a higher net capital standard than what the SEC mandates. And keep in mind that this is the firm we're talking about, not an individual. And one more point, we have a surety bond instead of a balance sheet that shows that net worth. 15, when reviewing the qualifications of a firm seeking licensing, I hate that word. Everybody uses it, drives me nuts. Seeking registration is the word I prefer. Registration as a broker-dealer or investment advisor. Which of the firm's personnel can the administrator consider in the registration review process? So, one of these people is different than the other. So again, a pivot word, clerical, right? So it's going to be A. Persons who have clerical personnel. Nope. The key pivot word, clerical. Sometimes they say on the test, solely clerical. See, not involved in the day-to-day operations. So yeah, it looks like A is the person. 16, how long must a investment advisor or broker-dealer required to keep records for review? I like this one. The answer is C. I hoping you're keeping 4x6 cards or a notepad and questions like this where Dean just tells you TQ doesn't mean you're going to get exactly a test question on it, but you're going to get something around that testable content. And then I would know that, remember that was 3 years for broker dealers, 5 years for investment advisors. And then once again, remember the state administrator cannot impose upon me a higher standard as a broker-dealer than I have to meet for the SEC. 17, a condition mandatory for the existence of a common stock. So common enterprise, excuse me. What they're getting at here is the definition of a security. And again, kind of like what I told you about a person. As a test taker, I wouldn't focus on what is a person for passing the 63. I'd focus on what is not a person. And again, as a test taker, I wouldn't focus on what is a security. I would focus on what is not a security. Right here, the answer is B. You know, right now, this is a big thing that the SEC continues to litigate with crypto guys. Like, are they securities or not? It's a big debate. So I don't particularly like the question, but you will get asked about what is not a security. For example, commodities aren't securities. Testable point, fixed annuities are not securities. So make sure you know what is not a security. Wouldn't worry too much about what is. I'd worry about what is not. What is not considered a security? Well, I just gave you the answer to this one. This is testable. And so the answer is A. You know, investment contracts like options can be traded to third parties for profits or losses. Treasury stock that is reacquired in the open market by the corporation is a security. And a certificate of interest, certificate means evidence, physical evidence. And if you have a certificate that's evidence of ownership and something, that can be traded to a third party for profit or loss. So the answer here is A. Commodities, by the way, commodities trade on futures market. Future contracts are securities, just not for purposes of the Uniform Securities Act. So commodities certainly are not. Futures contracts are, but not for purposes of the Uniform Securities Act. 19. Which documents do administrators review when evaluating the registration statement of for a security? The preliminary prospectus, the issuer's financial statements, the issuer's business plan. Yeah, what they really want to know is what you're going to be using to solicit the residents of his or her state. So given this answer set, D is the most appropriate response. If a state administrator plans to revoke the registration of a security, what must be provided to an issuer of that security? Very much a test question. Written findings of facts and conclusions of law. That's not only for the revoking of a registration of a security, but also the revoking of a registration of a person, natural, that would be you, agent of the broker-dealer, or unnatural, that'd be your broker-dealer, or investment advisor or investment advisor rep. So that's true of all of them. And that is a very good example of a test question you might encounter. Which investment is included? What is included in a prospectus, but not in the preliminary prospectus? Remember, the preliminary prospectus is also known as the red herring. And so, you know, we're going to make our S1 not testable registration statement or enter into the cooling off period or quiet time, which is a minimum of 20 days. And what I do during that cooling off period is I send you a preliminary prospectus, also known as a red herring, which has pretty much everything you need to know except the final offering price. And I can use that to solicit indications of interest, which are non-binding on all parties. I'm not allowed to advertise, but I can place a tombstone. And then remember, I'm going to have to coordinate this with the state administrator. I can't coordinate if I'm not doing a federal registration. So in terms of registering a security with the state, well, I like it. It looks like 22 now is the follow-up to that question. Registration by coordination refers to a procedure that reduces duplication of effort. Yeah, I don't like the duplication of effort, but you should certainly know what it's about. Right, I'm going to be registering with the feds under 33 at the same time that I'm registering with the state administrator. What prerequisite must an issuer meet for registration by notice filing? Right, so again, I think this is minutia. It's you have to have been in business for a minimum of 3 years, but I don't think I worry about that. You know, what you're going to get about notice filing is that federally covered investment advisors don't register with states, but may make notice filing. It's the easiest way to kind of do something. And, you know, I would know what is federally covered securities for, you know, that don't need to be registered on the Uniform Securities Act. So not a big fan of that particular question. Under which registration method does a registration for securities become effective at 3 p.m. Eastern time on the second business day After the registration is filed. Again, I just think this is kind of stupid as a test question. I told you, I don't think you're going to see that. I would know that qualification is certainly testable. Qualification is for where I can't coordinate and it's not federally covered. So I think you'll see B. It's not the right answer here, but that's the one I would know, particularly for like Rule 147, interstate offering. Again, not a question I worry about. Oh, here we go. 25. I would worry about registration through qualification. Which information about the issuer is not required? Well, you definitely have to tell the state administrator that your issuer's name and address. You have to tell them whether it's an LLC, an S corp, a C corp, a partnership. What is it? Certainly. A list of the owner's issuer's competitors. No. The equipment owned. Yeah, you're going to have a balance sheet. So that would be D, right? Because that would be on the balance sheet. So the answer is C. I think the most important thing to know about qualification is anything that you can't notify or coordinate must be done through qualification. That's the most onerous of the registration processes for a security. And I would have some general understanding of that in terms of it's the one thing, the effective is a year, not December 31st. Everything else is December 31st. I would know that the state administrator wants to know how much we're going to be selling in that state, right? Securities wise. So make sure you get a handle on qualification. 26. Under the anti-fraud provisions of the Uniform Securities Act, a state administrator can enforce securities fraud for which of the following? You shouldn't be struggling with this, everything. Securities registered with the state, federally covered. Yeah, just because it's federally covered doesn't mean, aren't I clever? I used a federally covered security to rip somebody off. No. No one and nothing is exempt from the anti-fraud provisions of the Uniform Securities Act, and for that matter, 33 and 34. 27, which securities are not exempt from registration with the state administrator? Securities guaranteed by an insurance company to finance a debt. Securities governed by the Public Utility Holding Company Act. Maybe I'm struggling with A, but I should know B. Well, it's not that public utilities get a free pass, it's they have a different regulator. Not exempt securities issued as a private placement. Federally covered securities. You should definitely know federally covered securities. Now, be careful. The private placement under the Uniform Securities Act is different. And remember, it's how it's sold. It's not exempt. It's how it's sold, right? So I'm not a big fan of that. But make sure you understand that the private placement under the Uniform Securities Act is different than a private placement under Reg D 33. Again, we're doing these real time. I'm not a big fan of question 27. 28, the federal act that prohibits state administrators from regulating securities already under the SEC's regulatory purview. I like this one. This is, something the state administrators didn't like because it took away power, right? The two big things this created were federally covered securities, New York, NASDAQ, mutual funds, and safe harbors like Reg D. And another thing it created was federally covered investment advisors. So, I would definitely know that. According to the Uniform Securities Act, what constitutes a fraudulent business practice? Unethical, a person intentionally acting in an unethical matter. So they're not asking about the person, they're asking about practice. A person intentionally acting in a deceptive, misleading manner. Yeah. See, that happens every day. That can happen just in the natural course of business. It doesn't mean I've ripped you off if you lose your money. Investment performance being inconsistent. Now that happens all the time. So I'm stuck between A and B. And here, B is going to be. Now, make sure you know the unethical practices would include very testable. Things like selling dividends, breakpoint sales, fictitious accounts. Very, very testable, all those unethical business practices. What is the definition of material fact? Well, I always believe in projecting the answer. So what I think of when I hear material fact, I think of a fact that would alter an investor's decision. I saw this securities professional being interviewed and they asked why he didn't tell the client this information. He said, I thought I'd lose the sale. I can't think of a worse answer than that. So now I'm going to look at my answer set, and this is what Dean is looking for, is something that approximates what I just said. Information provided by the board of directors of an issuer of a security? No. Information found in financial statements of an investment? No. Information found in the prospectus for a security? No. Information that an investor relies upon on whether or not to invest? Ding, 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 ding. So it's D. And again, if you're Dean, I think of it as something that would alter your decision. I say, listen, something might change your mind, but the key word phraseology on the test is we better make no omissions of material facts. No omissions of material facts. Which is considered a fraudulent act? Agreeing to perform services for clients it's not qualified to perform. Yeah, we got to know our limitations and say, listen, I have no expertise in that. B, failing to provide information that could impact. Yeah, that's omitting a material fact. That's a problem. Not disclosing transaction charges. That's a big no-no. Yeah, that's kind of a layup as 63 goes. All of the above. If you've been on the channel a while, I've had, I learned from you guys. I've had people say, hey, Dean, there's easier ways to do things that you're doing, like marking this up. I'm actually using the word thing and circling because it takes me less time. I'm trying to bring these in a timely fashion. And if I get the fancy annotation tool off Zoom, then it takes me longer to do it. But if you have some other, shortcuts, I learn all kinds of shortcuts from you guys. So if you have one, send it my way. Send it my way. Anyways, 32. How does the Uniform Securities Act define inside information? So again, I'm looking for material non-public information. Material non-public information. So A, so I'm projecting that, and now I'm going to look for something. One of the challenges on the Uniform Securities Act is figuring out what you're being asked, RTFQ, and then figuring out what's being offered to you as the answer. I was working with somebody, they said, Dean, I now know what I'm being asked. I'm still struggling a little bit with what the answers being offered to me are. So facts that have not been made public, that sounds pretty damn good. Let's see what my other choices are. This is a choice you make as a test taker. So, when you're doing your practice questions like this, maybe you want to go slow and read them all. But, if I'm taking the actual test, maybe I don't want to burn up brain cells unnecessarily. And I might make a choice just if I get A. I do like to read the answer set just to see if there's not an answer I like better. But if I feel pretty comfortable with that, which I do in this case, maybe I just want to go on to my next performance opportunity. Client account information, the securities must maintain. No. I mean, I do have to have custody, but that's not what this is about. The question isn't about that. Information securities delivers to enable to make an investment decision. No. Information provided to a client. No. A is the best answer. Under what securities may a securities professional borrow securities from a customer? Make sure you're careful about this because this is different under the Uniform Securities Act than it is for a broker-dealer. And here they're not distinguishing with me which this one is. So securities professional, I don't like that it doesn't tell me that. On the Uniform Securities Act, we should say never, with the exception of an immediate family member. Now, on the broker-dealer side, it would be okay with proportionate capital. Well, let me just see what my other answers are. If the client initiated the transaction, when the client offers securities loans, I like this one better. And here's why I like this one better. That's a bank, actually. The test is written in the 50s. So when the client offers securities loans as a regular part of a business. So this could be a margin account at a broker dealer or a loan from a bank. The key phraseology for you on the test is going to be the security professional borrowing from a client would be okay if that is a unnatural person, a lending institution like a broker dealer bank. So it won't be okay if it's a natural person. Now on the security side, there are exceptions to immediate family members and proportionate capital, but we're going to go with the Uniform Securities Act, which is a little more stringent. 34, which activity is prohibited when recording transaction in a client's account? So prohibited, not recording the transaction at the request of the client. No. Confirming client's order specification over the internet. Backdating, big no-no. So 34 is C. The excessive markup is not considered an act of fraud when the broker-dealer informs the client of the incorrect markup, The quota markup is represented as an industry standard. The markup was a clerical error that broker dealers of the markup. Given that answer set, I think clerical error would be the most acceptable. Again, I'm doing this real time. I'm not a fan of some of these questions, particularly this one, but given that answer set, I'm using my Sesame Street trick to say, that seems like the one that's least likely to be a problem. Well, there's two nasty words that we don't use in the securities industry. They're guarantee and approve. So under the Uniform Securities Act, what type of guarantee is prohibited? A guarantee has been verified by a third party. So here it might be like a bond that's guaranteed by the company parent being the third party. That's okay. Got to make it clear it's the third party and not me as a rep or not the firm. A recommendation based on prior year financial statements. We do that all the time. A guarantee based on the prospectus. I'm not sure about that. I don't know under what circumstance there'd be a guarantee in the prospectus unless, again, it's a security with a put provision or something like that. A guarantee of future performance, and now that clears it up for me. I said my crystal ball is broke. We should be able to say in our sleep that past performance is not indicative of future results. So that took care of that one for me. The answer 36 is D. Giving the false impression of volume is a big no-no. And a matching purchases when nobody's really trying to do a legitimate securities transaction. So matching purchase, significant increase in the outstanding shares, no. Yeah, an artificial increase in the market value of the security. So I sell it to you at 37, you sell it to me at 37.05, I sell it back to you at 37.10. People go, oh, something's up. No, right? So that's giving the false impression of volume. Big no-no. That's such a classic. It has a name called painting the tape. Painting the tape. Big no-no. 38, in addition to client authorization, what else must a securities professional obtain when establishing a margin account for a customer? Yeah, we have to have a written margin agreement that, says, hey, you understand that you're, pledging your securities as collateral for a loan. You understand you're borrowing money and paying interest. You understand that borrowing money is hazardous to your financial health, that the same supercharged speed you're going to make money with is the same supercharged speed you're going to lose money with. Segregation on the test is good. Commingling is bad. So segregating clients' accounts is a practice wherein each account may only contain the funds belonging to one customer. Client funds must be deposited with a financial institution not affiliated with a broker-dealer. Well, I could toss that out because lots of broker-dealers do have custody of client funds. So B's out. Broker-dealer funds must be held by custodian. No, I don't need a custodian to hold my broker-dealer funds. No, that's out. Client-owned securities may not be placed in a broker-dealer's account. Yeah, segregation between the broker-dealer and the client is what this is about. Most of us will have customers commingled. What I mean by that, it's okay to have all the customers' monies and securities in a customer location and broker-dealer separate. What wouldn't be kosher is to have the customer securities with the broker-dealer securities. So D. A broker-dealer participating in a public offering must make a percentage. This is kind of a stupid question, but it's 100%. You're not supposed to fail to make a bona fide distribution of the security to the public. Yeah, kind of a stupid question. Under what circumstances may a registered rep represent multiple registered broker-dealers? This is testable. This is testable. With written permission from the broker-dealer, no. When the broker-dealers are affiliated with each other. So, at a large, global financial superpower, like, JP Morgan or Bank of America or BlackRock, there may be more than one broker-dealer. And so those broker-dealers are affiliated, and that would be okay. Before recommending investments, a securities professional must obtain and consider client information integral to, this is the your customer rule, very testable, the client's investment goals, the client's risk tolerance, the amount the client can afford, the client's financial condition, right? So, again, I don't like this answer set a whole lot because I would like to get all of them. But, we're going to start with, how much are you going to be investing, right? Which information is used when making an investment recommendation? Oh, this one's easy, right? The rumors, no. Our marketing literature, no. Variable fileable facts. There you go. Yeah, that's this 63 goes. That's one you should be able to get. That should be aim and shoot, point and click. Angels weep for you if you miss aim and shoot, point and click questions. Under what circumstances can an investment advisor, keyword, be careful on the test. This is not about a broker dealer. It's about an investment advisor, share in a client's profits or losses. The client has provided written approval. The agent, that means broker dealer. So you're an agent of a broker dealer. And it looks like from the question, the setup is you're also representing an investment advisor. So agents of broker dealers can share in customer accounts with proportionate capital and principal approval. And so the answer here is D, or B as in boy, excuse me. So boom. Again, I would know that. I don't like this phraseology, but make sure on the test, agents of broker dealers can share in customer accounts with proportionate capital and principal approval. I don't know of any firm that's going to let you do that. House requirements can certainly be more stringent, and most of them are. When may an investment advisor release information about the client's investments? This is testable, right? The only circumstance, regulation SP again, right, is when I'm legally ordered to do so. I'm supposed to keep your information, protect your confidential information. So, the answer is D. That is very testable, very testable. 46. What must an investment advisor do when a material conflict of interest impairs its ability to provide investment objective advice? Listen, on this test, sunlight's the best disinfectant. And so I make written notification to the customer. 47, under what condition can an investment advisor maintain custody of customer accounts? As long as the administrator doesn't specifically prohibit it, we can do it. So the answer is D. It's the policy of the broker dealer. No, it's not about a broker dealer. It's about the investment advisor. With written permission from the client, under written permission. No, it's always about the administrator, right? So some states, the administrators say, I'm not going to allow you to have custody. You're going to have to use a broker dealer to do that. Which other role as an investment advisor would make it permissible to loan money to the customer? As we said, the key word you're looking for on the test is this idea that it's a financial institution, right? The investment advisor is a finance. I don't like that we're not making clear these are affiliates of the investment advisor, like Bank of America Wealth Management is the investment advisor, and then there's Bank of America, the bank that's a financial institution. So as I said, we're doing these real times. So B is the best answer there. And their roles as fiduciaries, must provide clients with sound. No, that's an agent of a broker dealer. And agents of broker dealers are not fiduciaries. Investment advisors are. And the whole point of being a fiduciary, I like this question, is you're supposed to be making decisions that are in that third party's best interest, not your own, right? So that's what this is saying. You can't promote your own interests as a fiduciary above the interest of your clients who you are their fiduciary. You got to make decisions that are in their best interest. Authorization. How often must an investment advisor obtain client authorization for securities transactions? Again, I'm just doing this real time, and I just don't like this at all. This question I think is just stupid, but if I have discretion, this is not true, right? But if I don't have discretion, then I have to do it before every transaction, right? I don't know of any investment advisor that would not have discretion, right? So if I don't have it, then it's a C. There's nothing in here about having discretion. Before the first transaction, the client has provided written authorization. On the broker-dealer side, that's true. On the investment advisor side, that's not true. Before receiving instructions from a third party, yeah. Not a big fan of that question. Not a big fan of that question. 51, which information is not permissible content in an investment advisor's advertising materials? They are changing testimonials, so check with your test prep vendor, but this is asking about our advertising materials, promotional materials. So the answer is D. What information must an investment advisor disclose to a client when using a report prepared by another party, third party? This is very testable. The name of the third party. We're not supposed to make it look like we're the ones that are generating that research. So I like that one. That's a good one. I would expect something around that area on your exam. Under what circumstances, the state administrator authority not limited to the individual state of the jurisdiction? Yeah, NASA, the North American Securities Administrator Association, recognizes each other's subpoenas across state line. So if I'm the Nevada state administrator and California asks me to enforce a subpoena, I'm going to say yes, right? So they all cooperate with each other. So B. 54, how does an administrator prevent an anticipated violation of the Uniform Securities Act? They issue a cease and desist order. Key point here is anticipates. Not something you haven't done it yet, right? So, which condition exists for an administrator to have jurisdiction over a securities transaction? I like this one. The transaction must originate within the administrator state. So, I'm coming from Nevada, and the offer originates or sale, right? And by the way, sale offer is the same as a securities transaction. So yes, Nevada. I direct it to California. So I directed my offer from Nevada to California. California now has jurisdiction. My customer says, Dean, let me think about it. And call me back tomorrow at this time, and I'll let you know where I'm going to move forward with this recommendation, this offer, accepted, a sale transaction. And I call him. I said, what's the background noise? He says, well, Dean, I'm in a wine tasting here in Oregon. And, I've decided to move forward with that. So the offer was accepted in Oregon. All of those state administrators have jurisdiction. Now, where they don't have jurisdiction is where the check was drawn. So, my customer says, Dean, I'll be having my family office in North Dakota send you a cashier's check. We do our banking in North Dakota. North Dakota has no jurisdiction over this scenario I just laid out for you. I say, great. When we get the cashier's check, I'll call the transfer agent in Colorado and have them send you your stock certificates. And then Colorado has no jurisdiction. So it's not where the check was drawn or mailed from, or where the transfer agent, the stock certificates are coming from. So, there you go. So in my example, I had 5 states there, right? I had Nevada, California, and Oregon, which do have jurisdiction. And then Colorado and North Dakota who do not. I have a whole video on jurisdiction. So if you ever, want requested lectures, just let me know, because they end up, what I think is popular is not always the case. And some guy said he wanted a little video on that. I did, and it's been very popular. So I need to listen to you guys, right? Which of the following is not a considered security? By the way, these practice exams are also very popular on the channel. I'm not so, by the way, this will be, I think, 3. You have a Kaplan 63 practice test. You have a Test Geek 63 practice test. Now you have Mometrics. The Test Geek practice exam for 63 has very strong correlation to the actual exam. The Kaplan is good. It's a little tougher. And this one we're doing on the fly. I'm not going to rank them, but if I were, I don't rank the practice exam in the playlist by which one I think is best. But if I was, this would still be number 3 considered compared to the other 2 you have in there. Which of the following is not considered a security? One party, securities transferred for value. That is definitely a sale. One party extends an offer to transfer ownership of a security for an item of value. A party offers a security as an incentive to sell a non-security. A party pays for services. Again, I'm not so sure I like this question, but given this answer set, I'm going to go for B, even though I don't really like this question. A state administrator ensures that investors are protected by issuing orders. Yeah. You know, this, I joke the SEC is God and state administrators think they are. So, you know, the SEC is God and state administrators think they are. So there's like 50 demigods running around and they issue orders. Do they assess are protected by assessing penalty levying fines? That doesn't really protect you. That's after the fact, right? B, C, and D are after something bad has happened. So given that answer set, A is the best answer. What action may a state administrator take if an applicant does not meet the minimum required financial standards? Deny the applicant's registration? Yes. I had a guy who had a bankruptcy and the state administrator asked him for further disclosures and wasn't happy with that and denied his registration. Suspend the applicant's registration? By the way, I was surprised by that because most of state administrators ask you to explain it and it's not a big deal. Suspend the applicant's registration? Yes. Revoke? Yeah. Any of the above. A state administrator may cancel a registration when the registrant has committed a fraud, the registrant has manipulated a customer account, the registrant has churned a customer's account, the registrant is no longer considered a legal person. Remember this, declared mentally incompetent or deceased. So given this answer set is D. I don't like the phraseology because they could do that for all those other reasons, but they're getting at this idea of D. The key word here, by the way, is cancel, right? Sometimes we say non-punitive on a non-punitive basis is the phraseology on the test. Which is critical when proving fraud in a securities transaction? Misleading information must have been provided. Well, you know, maybe it was an accident. You know, you got to have intent. I'm told you're taking a legal test. Sometimes I get attorneys taking this and they can say, Dean, man, if I miss it, it's going to be embarrassing. I go, absolutely, it'll be embarrassing. B, a recommendation based on false information has been made. Yeah, again, I don't see any intent on the false information. By the way, A and B are bad, but I don't see intent there. A person withheld information. Well, I might have done that to help you. I mean, I'm allowed to make editorial decisions and omit immaterial information, material information that was important to making the decision. So remember, there's a difference between omitting material information, the information that you need, that you didn't have, might alter your decision versus immaterial. So sometimes, why didn't you disclose it? And you don't want to be in trouble. You say, well, I didn't think it was material. So C is not fraud. A person deliberately, there we go, in a matter designed to mislead. Yeah, that's the problem, right? That's the problem. Okay, so I hope you found that helpful. You can find the answer key and any comments I have in the video description. Remember, inch by inch, your 63 is a cinch, yard by yard, your 63 is hard. And I hope you found this helpful. Let me know your comments on Momentrix in this practice exam. Like I say, we just did it real time. And I don't think I missed any, but we'll go back. If I do, I'll certainly put that in the comment section when I do video descriptions. So like I say, I'd be interested in your thoughts. Inch by inch, 63 is a cinch, yard by yard, 63 is hard. If this is your last leg of your testing journey, woohoo! You got this, and you'll be ready to put your registrations to work. If it's not, then I imagine ahead of you becomes the 65. Ugh. Now, good news, if the 65 is ahead of you, a lot of overlap on the regulatory side on 63 and 65. So make sure you dig in here on the 63 so you can get learn it once and get tested twice. Bye-bye.